The insurance company's job is to close your claim for as little money as possible. That's not cynicism, that's their business model. And they're very good at it because they use the same tricks on the same people in the same order every single time. 5 of those tricks, the ones I've watched destroy cases worth hundreds of thousands of dollars in California. Number 5 is so subtle most people never see it coming. Number 3 catches even claimants who know they should be careful. And the number 1 trick, the one that works on almost 90% of people who file a claim, they run it before you've even thought about calling an attorney. So here's all 5. Number 5, the sympathy play. Maria gets rear-ended on the 405 on a Tuesday afternoon. By Wednesday morning, her phone rings. The voice on the other end is warm, calm, almost kind. Hi, I'm calling from the claims department. I just want to make sure you're okay and help you get this resolved as quickly as possible. That warmth is a tactic. The adjuster's job in that call is to make you feel like they're on your side. And it works because most people want to believe that. They open up. They share details they didn't need to share. They describe how they feel in ways they'll regret later. They stay on the call for 20 minutes instead of saying politely that they'll be in touch. Under the California Fair Claims Settlement Practices regulations, insurance companies are required to investigate claims fairly. They are not required to investigate in your favor. Those are completely different things. The adjuster who seems the most helpful is often the one building the strongest case for a low settlement. Number 5 is subtle. Number 4 is less warm, and it usually comes up in that same conversation. Number 4, the rush medical question. David is still at urgent care when the call comes in. The adjuster sounds professional, says it's just a few quick questions to get the file started, and then, and how are your injuries today? Any pain you're experiencing right now? Honest answer, honest mistake. Adrenaline masks pain. Soft tissue injuries can take 48 to 72 hours to develop, sometimes longer. A concussion symptom might not appear for a week. A disc injury might not show up on an imaging until all the swelling has gone down. Whatever you say in those first 24 hours goes straight into the file. When your medical bills start coming in for a neck injury that you described as, quote, not too bad on that first call, that statement becomes the adjuster's argument that your treatment isn't related to the crash. You say, Steve, but I was just being honest. My injuries really weren't that bad in that first conversation. I understand that. And I'm not saying you were wrong to feel that way. But an accurate description of your condition on day 1 is an incomplete description by day 5. You don't know yet what the full picture is. Doctors don't even know yet. And once that statement is in the file, the adjuster will use it every time your medical records say something different. Number 3 is where it gets harder to resist because it sounds completely reasonable. Number 3, the false deadline. James is 3 weeks out from a side impact collision. He's doing physical therapy, he's getting imaging done. The adjuster calls again, and this time the tone has shifted. We want to get this file closed out for you. If you can give us a statement and we can agree on a number this week, we can get you paid quickly. After that, I can't make any promises about where this file goes. Let me tell you something right now, there's no deadline. In California, the statute of limitations for a personal injury claim is generally 2 years from the date of the accident. That's Code of Civil Procedure 335.1. You got 2 years to file a lawsuit. The urgency the adjuster is creating is manufactured pressure, not legal reality. The reason they want to close your file this week is simple. The longer you wait, the more you know about what your case is actually worth. And that knowledge is a threat to their settlement offer. Under the California Fair Claims regulations, the requirement is that insurers accept or deny a claim within 40 days of receiving proof of that claim. They have legal timelines to meet. You don't have the timeline they're describing. That's pressure, it's a script, and it's not a legal fact. So they can't force your hand with a deadline. But number two is the one that makes the pressure feel like it isn't even necessary. Number 2 is the lowball early offer. Keisha gets rear-ended on the 10. Classic whiplash. She's sore, she's getting checked out, and 2 weeks after the crash, the adjuster calls with an offer. $4,500. Settle your claim today. We'll get you a check by the end of the week. It sounds real. It sounds like a resolution. It's neither one. At 2 weeks out, Keisha doesn't know yet what her full medical costs are going to be. She hasn't finished treatment. She doesn't know if she'll need an MRI, a specialist, months of physical therapy or care that extends into next year. She doesn't know the full picture of her wage loss. The offer isn't based on what her case is worth. It's based on closing the file before she figures that out. You say, Steve, but I need that money right now. My car is in the shop, I have bills, and $4,000 is real money. I hear that, and it is real money. But when you accept that offer and you sign the release, you are closing your claim permanently. If your treatment runs $12,000 and you miss 3 weeks of work, you've signed away tens of thousands of dollars for a check you can cash this week. California law does not give you a do-over after you've settled. That release is final. That offer is not based on your actual damages, it's based on your desperation. Now you understand why number 1 is the most dangerous thing on the list, because it happens before any of these other 4, before you've even thought about any of this. Number 1, the recorded statement. The call comes within hours of the accident, sometimes the same day. The adjuster sounds polished, professional, helpful, and somewhere in the first 2 minutes, almost as a formality, I'll need to record this call for our records. Is that okay? Most people say yes, almost automatically. Here's what you're agreeing to. A permanent on-the-record account of the accident, your injuries, and everything you know, given while you're still shaking, while the adrenaline is still in your body, while you don't even know the full extent of what happened to you. That statement doesn't go away. Whatever you said about how fast the cars were going, where you were looking, how you feel right now, that is now the official record. If your account changes later, even because you remembered something new or your injuries developed, the adjuster will use that inconsistency against every medical bill that follows. Let me make this clear. You are not required to give a recorded statement to the other driver's insurance company. Under Penal Code Section 632, California is a 2-party consent state for recorded calls. The adjuster is legally required to inform you that the call is being recorded and get your consent. That consent is yours to withhold. You can say, I prefer not to give a recorded statement right now, and I'll be in touch. That's not obstructing their investigation. That is your legal right. Under the California Fair Claims Settlement Practices Regulations, they require insurance companies to investigate claims fairly and to communicate clearly and honestly with claimants. They did not require you to help them build the case for the minimum possible payout. In 30 years of representing injury victims across California, I've seen every one of these 5 tricks, but the recorded statement is the one I see ruin cases most often because it is the first move, and most people have no idea they can say no. You can. If you drive in Los Angeles, there's a second video you need to see before you click away. I put together a breakdown of the most dangerous roads in Los Angeles. This is ranked by actual crash per mile data. The numbers are worse than most people expect, and knowing them changes how you think about your daily route. That video is on the screen right now, so check it out.